everybody, this is Tracy here with another edition of A View from Tracy's Point. And I know it's been a minute since you guys heard from me, but I am back, okay? And so today we are going to go over a document that was filed by the Northern District of Illinois in their case against Robert Sylvester Kelly. And this document is called a Santiago Proffer, and it's where the government is basically outlining some of the information about their case and how they plan to present that case. So hold on a second and we'll get into that in a moment. Okay, guys, so before we get into the Santiago Proffer, I want to let you guys know that I've still been going over the documents that are being filed in both the Eastern District of New York and the Northern District of Illinois. I received my Pacer bill the other day and I was like, oh Lord, this stuff is piling up and I need to get in here and do these videos because it makes no sense for me to keep downloading these documents if I am not going to share them. So some of the things that we're going to cover, I told you in the introduction that we were going to do this Santiago Proffer first, but I also have information on the Jennifer Bonjean filing her appeal in the Eastern District of New York's verdict. And then in the Northern District of Illinois, you guys know that that case starts on August 1st. I believe that's when the jury selection will start, so it may be like another week or so. Actually, I think they pushed that back, didn't they, to August 15th? Yeah, I believe that the Chicago case has been pushed to August 15th. But in any event, whatever day it starts, that's when jury selection starts. And so the actual trial may not begin until a week or so later. And right now they are in the process, what is called, where they filed the motions in limine. And if you recall from the Eastern District of New York case, the motions are filed where the government, files information about the charges that they're bringing. And then the defense gets to file motions asking that certain charges be dismissed, that certain, information that the government plans to present, not be presented. They're arguing about the charges and the legitimacy of the evidence and that type of thing. And so I have several documents on that I need to bring to you all. And what else? Oh, you guys know that Jennifer Bonjean had filed a motion to dismiss and a motion to sever this case from the Derrel McDavid case. And the judge did rule on those two motions and basically denied both of them, saying that all three defendants need to be tried together and that she didn't provide, enough reason for them to dismiss the charges. And keep in mind, when the defense is filing these motions, they don't really expect the judge to rule in their favor. Sometimes the judge rules in their favor, but in most instances, the judge is going to deny those requests. But the reason that they filed the motions is so that they get a record that they objected to some of this stuff, that they questioned some of this stuff. And that way, if the defendant is found guilty, then they have a record in which to go to the Court of Appeals to argue their case in the Court of Appeals. And that is exactly what is happening with the Eastern District of New York case, where Jennifer Bonjean has pulled motions from that Thomas Farinella was filing at the beginning of the case, as well as her own motions that she filed post-trial. And that is the information that she is going to use to try to get the district court, the district, the second district of appeals, to try and get them to hear the case. And I've shared with you guys before that they are under no obligation to hear the case. As you know, Harvey Weinstein appealed his guilty verdict in New York, and the appeals court ruled that they were not going to hear his case, that they felt that he had nothing to argue, that the case was fair to him, and that he had no grounds for an appeal. And so that is basically what is going to be the procedure with Jennifer Bongine with the Eastern District of New York. She presents her case. Well, not the full case, but she requests the appeal. They'll review the documents that were used in the case, the motions that were filed, and that type of thing. And then they'll come back and let her know whether or not they are going to hear the appeal or not. And so it's really a wait and see game to see how long it's going to take them. I believe it took in the Harvey Weinstein case several months for them to come back and say that they weren't going to hear the case. So, once again, just have to wait and see what is going to happen. And I keep saying that they said that they weren't going to. I don't think they heard the case. I think they just reviewed the documents to see if there were grounds to hear the case, and they chose not to, and they upheld the conviction. But I could be wrong, and if I am, please let me know in the comments, because I have no problem correcting myself when I give out incorrect information. So I was trying to figure out what in the world is a Santiago Proffer. And usually when I come across a term in these cases and I don't know the meaning, I just put in the description, what is this? And I get a quick return. But for some reason, I just kept getting case after case after case after case. And then I eventually found a forum where these people were talking about a case, and people were asking, what in the world is a Santiago Proffer? And someone way down in the comments finally came back with an answer, and this was their response as to what is a Santiago Proffer. So it says, and they started off with a little joke, it says, the Santiago Proffer is not a new blockbuster book by John Grisham, who I might add is one of my favorite mystery writers or true crime writers. It says it's not a courtroom thriller starring Tom Cruise. It is a boring legal filing. It is mostly used in conspiracy cases, especially organized crime or political corruption. Proffers are outliners of evidence to be presented by the prosecution. The Santiago Proffer is a very specific and detailed outline. It is a broad map to the prosecution's case. It states the bulk of the prosecution's case. It may contain statements of cooperating co-conspirators, witnesses, or other evidence not presented earlier. It connects the dots between all the co-conspirators, witnesses, and evidence to the defendant. Prosecutors tried to keep a Santiago Proffer under seal from the public for various reasons. Well, it seems in this case they weren't trying to keep it under seal, and the only reason I can come up with that they were okay releasing this is because they know that there are people on YouTube that are covering this case who is going to read the document as I am about to do. And so their goal is they want this information to get out there, and they want the public to consume this information so that it taints public opinion and it taints the jury pool, because they figure if they put all this, like, oh my God, aha moments in this document and it gets out, then people are going to lean toward, oh, he's guilty. He's got to be guilty. The government has all this evidence against him. And that's why it's so important to find people that are willing to step forward and say, hey, they are doing this man wrong, and we can't stand by and allow this to happen to him. And so it seemed that after the New York verdict, there was a little kind of like people were waking up saying, wait, they gave this man 30 years for what? So it was a few people that were waking up saying, oh, they gave this man too much time. They dogging this man out. But unfortunately, they woke up too late, okay, because, it's already been done. The damage is out there, and there's really not much that can be done to fix it. And so this is a 41-page document, guys. So you know it's about to be long and boring, okay? But please hang in there and stick with me. And let's see what we can do here. And so we guys know that this is the Northern District of Illinois versus Mr. Kelly and his co-defendants Derrel McDavid and Milton June Brown. And so it says government Santiago Proffer and motion to admit evidence pursuant to federal rules of evidence 801 D2E. The United States, wait, hold on a second. You guys know when I get to trying to scroll on this doggone laptop, I'll be having a time. So it says the United States of America by its attorney John R. Losh Jr., United States Attorney for the Northern District of Illinois, moves to admit certain statements against defendants Robert Sylvester Kelly, Derrel McDavid, and Milton Brown pursuant to federal rules of evidence that I just read to you in the opening. And then we have the introduction. It says the defendants are charged with participating in conspiracies involving obstruction of justice and the receipt of CP in the form of recordings. In this submission, the government provides an overview of the charged conspiracies that will be established at trial, describes the law governing admissibility of co-conspirator statements, and outlines some of its evidence establishing the charged conspiracies. Based on the following, the government seeks admission of statements pursuant to Rule 801 D2E and requests a pretrial ruling of admissibility from the court. In accord with United States versus Santiago, 582 2nd District, and it gives all the case numbers and where it's located. 7th Circuit in 1978, which is when the case was heard. An established practice in the circuit, the United States versus Alvear, which is another case heard in the 7th Circuit in 2009. United States versus Harris, which was heard in the 7th Circuit of 2009. And these are cases that they are citing to support this document. This submission does not detail all the government's evidence that would go to show the existence of the charged conspiracies or all the conspirator statements that were made in reference of the charged conspiracies. Rather, the submission highlights for the court certain of the government's evidence sufficient to establish the existence of the obstruction of justice conspiracy described in Count 5 and the related receipt of CP conspiracy described in Count 6 and the participation of the co-conspirators. As a result, the submission does not list all the government's evidence and witnesses, nor does it provide all the evidence that will be presented by identified witnesses. Background. Overview of the charged obstruction of justice conspiracy. The superseding indictment alleges that from approximately 1996 to 2001, Kelly engaged in contact with Roshona Landfair and then four other individuals. As part of this abuse, Kelly recorded himself engaged in conduct with the individuals on videotape. During this time, from approximately 1991 until 2014, during this time, from approximately 1991 until 2014, Kelly and or one of Kelly's businesses employed McDavid as Kelly's business manager. Child, I thought they was about to say some of this stuff was going on as early as 1991, but they're talking about when he met Derrel McDavid. So he employed McDavid as Kelly's business manager. As a business manager for Kelly, the services McDavid provided to Kelly and for Kelly included protecting Kelly's image, reputation, and assets when victims of Kelly's abuse pursued or were part of civil actions. Count 5 of the superseding indictment charges Kelly and McDavid with conspiracy to obstruct justice related to CP and CP. McDavid and others knew of Kelly's misconduct and knew that Kelly recorded himself engaging in such conduct on videotape. In approximately 2001, Kelly and McDavid learned that multiple such videos were missing from Kelly's collection, including videos 2, 3, and 4. After making this discovery, Kelly, McDavid, and others conspired to conceal and cover up evidence, including videos relating to Kelly's contact and acts with others. Kelly, McDavid, and others also agreed to intimidate, threaten, and pressure others to falsify and make false entries in records and documents related to his misconduct with individuals. To accomplish this, among other things, Kelly and McDavid agreed to pay others to collect and return incriminating videotapes and to keep silent about Kelly's relationship with Rashona, among others. Further, Kelly paid McDavid to ensure McDavid would continue to conceal and cover up evidence of Kelly's misconduct. Based on these and other facts, Kelly and McDavid are charged with conspiracy to obstruct justice relating to exploitation and porn. Overview of the receipt of the CP conspiracy. Count 6 of the superseding indictment charges Kelly, McDavid, and Brown with conspiracy to receive CP. Brown, like McDavid, provided services to and for Kelly for years. Count 6 alleges certain paragraphs from Count 5, including those referencing Kelly's conduct and acts with individuals and Kelly's recording of those encounters. Kelly, McDavid, I think they mean, and Brown knew of Kelly's recorded activity, and when they discovered that certain of the videotapes were missing, they paid others to recover and return certain videotapes. Specifically, between August 2001 and April 2007, defendants conspired with each other, individual A, individual B, and others to receive video 2, 3, and 4. And I think we found out that individual A is a private investigator that was supposedly hired by the Jensen attorney guy who is no longer alive to support that notion. And that individual B, I think we decided was Yul Brown, who was a former boyfriend of Lisa Van Allen. So they go into the argument and it says 1, governing law. So Rule 801D2E provides that a statement is not hearsay if it is offered against a party and is a statement by a co-conspirator of a party during the course of and furtherance of the conspiracy. Admission of such co-conspirator statements against a defendant is proper where the government establishes by a preponderance of the evidence that 1, a conspiracy existed, 2, defendant and the declarant were members of the conspiracy, and 3, the statements were made during the course and in further of the conspiracy. United States versus Cruz Ria, which was heard in the 7th Circuit in 2010. Under Santiago, the trial court must preliminarily determine whether statements by a co-conspirator of the defendant will be admissible at trial under Rule 801D2E. In making this determination, the judge must decide if it is more likely than not that the declarant and the defendant were members of a conspiracy when the hearsay statement was made, and that statement was in furtherance of the conspiracy. And then they cite the Santiago case, and then also United States versus Hoover, which was heard in the 7th Circuit in 2001. If the court determines that the statements are admissible, the jury/court may consider them for any purpose. United States versus Thompson, 7th Circuit, 1991. So they're showing how they're going to set this thing up using what I'm assuming is statements from Derrel McDavid, the private investigator, and then Yul Brown. So A, existence of and membership in the conspiracy, not the membership. In making the initial admissibility determination under the Santiago criteria, A court can consider the statements in question, those to be admitted. See Burjali versus United States, which was heard in 1987. While a court may consider the proffered statements themselves as evidence of both the existence of a conspiracy and a defendant's participation in it, the contents of the proffered statements alone are not sufficient to establish the existence of a conspiracy and a defendant's participation. Instead, there must be some supporting evidence or facts corroborating the existence of the conspiracy and the defendant's participation in the conspiracy. The evidence showing the existence of a conspiracy and the defendant's membership in it may be either direct or circumstantial. Okay, and they quoted a bunch of cases, but I'm not reading all that. Okay, so there is no requirement for admissibility under Rule 801 D2E that the government establish all elements of a conspiracy charge, such as a meeting of the minds and an overt act. United States versus Co., 7th Circuit, 1983. The government need only establish the existence of a joint venture for an illegal purpose and participation in the joint venture by the defendant and the maker of the statement at issue, as well as that the statement was a furtherance of the venture. It makes no difference whether the declarant or any other partner in crime could actually be tried, convicted, and punished for the crime of conspiracy. Let's read that again. The government need only establish the existence of a joint venture for an illegal purpose and participation in the joint venture by the defendant and the maker of the statement at issue, as well as that the statement was a furtherance of the venture. It makes no difference whether the declarant or any other partner in crime could actually be tried, convicted, and punished for the crime of conspiracy. So I guess they basically telling us that there are some players in this that they ain't charged and who ain't gonna face trial for this. Sort of like what happened in the Eastern District of New York. So it says, although as discussed above, there is a distinction between conspiracy law and admissibility under Rule 801 D2E, certain principles of general conspiracy law are relevant to the Rule 801 D2E inquiries. For instance, a conspiracy may exist even if a conspirator does not agree to commit or facilitate each and every part of the substantive offense. Salinas versus United States, which was heard in 1997. And then they give some more cases, not reading all that. The government need not prove that a defendant knew each and every detail of the conspiracy or played more than a minor role in the conspiracy. Now, doesn't this sound like the bribery charge where Demetrius Smith stated that he knew nothing about him bribing the public official, that he didn't know what else did they spend money on? So the $500 bribe, he didn't know about that. And it was something else he didn't know about. But then the government turned around and said it doesn't matter that he didn't know about it. He had told Demetrius Smith why he needed to marry Aaliyah, and that the money that was used to pay the bribe, Derrel McDavid had removed from his bank account. And because he had gave Derrel McDavid the authority to withdraw money, that made him guilty of a conspiracy and the bribery charge. So basically what they're doing is setting that same thing up here when it comes to them trying to bribe these people and buy back these videotapes. They're saying that it doesn't matter whether Mr. Kelly knew that this was going on, that they were doing it on his behalf and they were using his money to do it. So therefore they can find him guilty and charge him with this, and the jury can find him guilty of it, even if, he lacked knowledge or full participation in the scheme. So let's see. So it says, for instance, a conspiracy may exist even if a co-conspirator or conspirator does not agree to commit or facilitate each and every part of the substantive offense. And then I'm going to skip over these cases. The government need not prove that a defendant knew each and every detail of the conspiracy or played more than a minor role in the conspiracy. Further, a defendant joins a criminal conspiracy if he agrees with another person to one or more of the common objectives of the conspiracy. It is immaterial whether the defendant knows, has met, or has agreed with every co-conspirator or schemer. A defendant or other declarant may be found to have participated in a conspiracy even if he joined or terminated his relationship with other conspirators at different times than another defendant or co-conspirator. It is irrelevant when the defendant joined the conspiracy as long as he joined it at some point. Okay, so basically they're saying him finding out that Derrel McDavid was up to no good doesn't absolve him of being a co-conspirator in the crime that was taking place. So finally, the government is neither required to prove the identity of the declarant, nor must the declarant's identity be confirmed in the statement itself. So basically, anybody could be giving them this information, child. They say we don't need to know who they are. Rather, the government need only prove from the statement the context and other evidence that the declarant was in fact a co-conspirator. Okay, B, in furtherance of the conspiracy. In determining whether a statement was made in furtherance of the conspiracy, courts evaluate the statement in the context in which it was made and look for a reasonable basis upon which to conclude that the statement furthered the conspiracy. Under the reasonable basis standard, a statement may be susceptible to alternative interpretations and still be in furtherance of the conspiracy. The co-conspirator statement need not have made exclusively or even primarily to further the conspiracy to be admissible under the co-conspirator exception. So, child, they just they just making it up as they go, y'all, and say that it stands because they say so. So courts have found a wide range of statements to satisfy in furtherance requirements. United States versus Caso. In general, a statement that is part of the information flow between conspirators intended to help each perform his role satisfy the in furtherance requirement. United States versus Aviar, and then United States versus Jago, not sure how to pronounce that. And then they have, these include statements made, and then they talk about several cases to conduct or help to conduct the business of the scheme, and they give the court cases to identify other members of the conspiracy and their roles, to plan or to review a co-conspirator's exploits, as an assurance with co-conspirator can be trusted to perform his role, inform and under others about the current status of the conspiracy or a conspiracy's progress, including failures, to control damage to an ongoing conspiracy, to conceal a conspiracy where ongoing concealment is a purpose of the conspiracy, to reassure or calm the listener regarding the progress or stability of the scheme, to report conspirators' status and in turn receive assurances of assistance from co-conspirators, to describe the purpose, method, or criminality of the conspiracy, to recruit potential conspirators. And finally, it has long been the role that any statement made by a co-conspirator during and in furtherance of a conspiracy is admissible against all co-conspirators. And that was a case from the Seventh Circuit in 1937. And then they cite some more cases. And so basically those little blurbs that I read to you were rulings that set precedents in all these different cases in the Seventh Circuit that supports them saying that it doesn't matter if the defendant was a full, like, initiated the conspiracy, if any statement that he made during the conspiracy is found to be true, then he could be found guilty and they have the right to charge him. Alternative basis for admissibility. Many statements described herein and sought to be admitted against the defendant are independently admissible and do not require a Rule 802 D2E analysis. A defendant's own statements. A defendant's own admissions are admissible against him pursuant to federal rules of evidence without reliance on the co-conspirator's statement. United States versus Mahalis, 7th Circuit, 1993. Okay, Rule 801 D2A provides in pertinent part that a statement is not hearsay if the statement is offered against a party and is the party's own statement in either an individual or a representative capacity. Additionally, a defendant's own admissions are relevant to establishing the factual predicates for the admission of co-conspirator statements against him. United States versus Godness and United States versus Potts. Both of those were heard in the 7th Circuit. I'm sorry about that. Somebody sent me a text message. 2, agency statements. Statements made by a party's agent or employee on a matter within the scope of the employment relationship while it existed are admissible against him pursuant to Rule 802 D2D. Non-hearsay statements. The co-conspirator statement rule is not implicated where the relevant verbal declaration is not a statement within the meaning of Rule 801A, that is, not an assertion, subject to verification. An example would be an order or a suggestion. This is because a statement is defined as an oral or written assertion or nonverbal conduct of a person if it is intended by the person as an assertion. Thus, a statement which is incapable of verification, such as an order or a mere suggestion, is not hearsay and does not invoke a Rule 801 D2E analysis. Additionally, the co-conspirator statement rule does not apply when a statement is not being offered for the truth of the matter asserted and thus does not constitute hearsay as defined by Rule 801C. Accordingly, statements by alleged co-conspirators may be admitted against a defendant without establishing the Bajali factual predicate set forth above. When such statements are offered simply to show, for instance, the existence, the illegality, or the nature or scope of the charged conspiracy, and then they go on to cite where that statement came from. Boy, the person that was in that forum that said that this was a bunch of boring jargon were telling the truth. So I hope y'all are finding this useful. 4, statements against penal interest. Under Federal Rule of Evidence 804B3, a hearsay statement is admissible if 1, the declarant is unavailable, 2, the statement was against the declarant's penal interest at the time it was made, and 3, corroborating circumstances exist indicating that the statement is trustworthy. United States versus Lewis, 7th Circuit, 2011. When determining whether a statement is against penal interest, each portion of a proffered out-of-court statement is examined to determine whether it subjected the declarant to criminal liability. A statement may satisfy this requirement if it would be probative at trial against the declarant. Applying this standard, the 7th Circuit has held that a declarant's inculpatory statements made to friends and acquaintances about crimes committed by the declarant and his associates are admissible. So I guess they're saying if you share with somebody what you did, then they can go ahead and admit that as evidence, whether the person witnessed it or not. So holding that a jailhouse conversation between 2 co-defendants which incriminated a third co-defendant, but was also inculpatory of the first two co-defendants, was admissible against the third co-defendant. Affirming the United States versus Curry, 7th Circuit, 1992, affirming the district court's decision to admit a co-defendant's inculpatory statement, which also incriminated the defendant because it was not made in an attempt to curry favor with law enforcement, but was made as an acquaintance. So, child, be careful in that jailhouse, Mr. Kelly, because they just... Oh, and then that was the other thing I forgot to tell you guys, that Mr. Kelly was moved back to Chicago. So he's back in Chicago at the MDC, awaiting his trial in the Northern District of Illinois. So watch what you're saying to them people in that jailhouse, because I know they done planted some folks in there to try and get you to talk about how you feel about the guilty verdict in the Eastern District of New York, how you feel about your sentence, how you feel about the sentence that you received, how you feel about your appeal. They're probably going to be looking for information that they can get out of you to try and get you to plea out in this case and say, well, hey, you already been sentenced to 30 years in the Eastern District of New York. Go ahead and plead guilty and we'll only give you 15 years or something like that. So those will be the games that they're trying to play from now until August when his trial starts. So 2, the evidence demonstrating the existence of the charged conspiracies and defendants' participation in the conspiracies. The government's evidence of the charged conspiracies and defendants' participation in them consists of, among other things, 1, witness testimony including from unindicted co-conspirators and Kelly's victims, 2, videos containing CP, 3, polygraph examination records, 4, travel records, 5, bank and business records, and 6, the false documents created as a result of defendants' intimidation, threats, and pressure to persuade others to conceal and cover up evidence of his participation in misconduct. Now, child, what false documents are they talking about? A, testimony of individuals 1, 4, and 5. The government anticipates testimony at trial from individuals referenced in the indictment that Kelly engaged in acts with them when they were certain ages. These encounters took place at various times from approximately 1996 to 2001. And see, there's a note at the bottom that says the government has tendered to defendant all of the statements and reports of interviews to date of witnesses referred to in this section. The records and other documents referenced in this section have been produced to defendant in discovery. So they say he has all this information, y'all. So hopefully Banjin working with it, got investigators on it. So it says the evidence will establish that on many occasions, he recorded himself engaging in these encounters. The testimony that the government anticipates that these individuals will provide is summarized below. So Rishona is expected to say that she met Kelly around 1997 or 1998 when she was a certain age. Kelly began having a relationship with her, engaging in stuff with her at that time. From the beginning, Kelly told Rishona that she was not allowed to tell anyone. I turned my air conditioner off and the fan off, so this heat is like killing my throat here. Okay, let me go back up here. So from the beginning, he told Rishona that she was not allowed to tell anyone about their activities together. He told her that if anyone asks about their relationship, she should completely deny it and act offended that anyone would ask such a thing. Let's see, they had hundreds of encounters in many different places, including his home, recording studio, tour buses, and hotels. Child, where was your mama and your daddy? Hundreds of times? Rashona, why you got these people letting you get up there and lie like that? Girl, hundreds of times, Rashona. Come on now. Whew. So Kelly instructed Rashona what to do with him and others, including individual D, which we know as Lisa Van Allen. At the same time, he continued to engage in behavior with Rashona through and after she turned 18. When Rashona and Kelly were together, they often recorded themselves using a camcorder with VHS tapes. Kelly kept his video camera and the VH tapes with the recordings in his gym bag and on a shelf at his house, hidden behind other tapes. Kelly sometimes played tapes depicting porn while he and Rashona engaged in acts. Some of the tapes with Rashona and Kelly, and some depicted Kelly with others. Kelly took the gym bag with the tapes almost everywhere he went, and only let certain people he trusted carry the bag. Brown was one of those people. That child, where we come up with Brown? Who is, Milton Brown? Is that who they talking about? They just threw that in there randomly. Brown. Brown was one of the people whom Kelly trusted to carry the bag. According to Rashona, Brown knew that Kelly and her were doing the do. Child. Okay, y'all, Rashona, you throw everybody under the bus. So, child, videos 1, 2, and 3 contain footage of Rashona and Kelly engaging in activity at his house on West George Street in Chicago. Rashona, let's see, in video 1, Rashona is wearing a distinctive necklace. Rashona's passport at the time contained a photo of her wearing the same necklace. She discussed the passport photograph with Kelly, his lawyers, and McDavid because it showed her wearing the same necklace visible in the video. Kelly or one of his lawyers took the necklace from Rashona. Additionally, Kelly created other videos depicting him and Rashona engaging in activity together, as well as with others, including whoever number 5 and 6 is, and then Lisa Van Allen, all while Rashona, was under 18. Let's see, in or about 2000, when Rashona was about 15 or 16, government agencies began investigating allegations that Kelly was abusing her. Kelly instructed her on how to act and what to say if she was questioned. In or around December 2000, law enforcement officers from the Chicago PD questioned Rashona about her relationship with Kelly. During the CPD interview, Rashona followed Kelly's instructions and falsely denied the allegations, and CPD documented that information in a report. Around late 2001 or early 2002, when Rashona was 17, her family members learned about the first video, and some of them saw the video themselves. And then there's a note at the bottom that says that Rashona's passport was issued on or about March 16, 1998, when she was 13. Okay, so let's see. So Rashona continued, to deny the aspects of her relationship with Kelly to family and friends. However, McDavid set up a meeting at a hotel with Rashona, her parents, Kelly, and McDavid. During the meeting, Rashona revealed to her parents that her and Kelly had been engaging in acts when she was younger. Kelly told Rashona and her parents that they were either with him or against him, which Rashona interpreted to mean that if they all denied the allegations regarding Kelly engaging in acts with her when she was a certain age, she wouldn't have to worry about what could happen to her family. Shortly after the meeting at the hotel, child, that didn't even make no sense at all. And then, isn't that statement, ain't that the same thing that Cheryl Mike said, he said to her about the whole precious way, either you with me or you against me, you got to pick a side. Isn't that the same doggone statement? So they regurgitating information, y'all. So, child, what was that? Let's see. So, Kelly told Rashona and her parents that they were either with him or against him. Child, I would have got up and kicked his behind. And let's stick a pin here because people are weird. There is a case taking place here where I live at the MacDill. Well, I don't live on MacDill Air Force Base. I live near MacDill Air Force Base. But there is a case or accusation going on about the 13-year-old son of a military personnel at MacDill Air Force Base who allegedly assaulted these two sisters. Now, I can't remember if they're sisters or not, but they were two girls on the playground or something, and he supposedly assaulted them. And MacDill is like dragging their feet with the investigation. They won't do anything about it, and evidently there were other people that this boy has bothered and stuff. And so it turns out that at least one of the girls live next door to the 13-year-old boy, right? That y'all tell me what man could sit in the apartment next door to the person that has brought harm to his child and not go over there and kick his behind and kick his parents behind? Like, how do you walk out your front door and see the neighbors, knowing what the neighbors have done to your child, and not like they just want to go off, want to commit a crime and go to jail? Like, how do you patiently sit by and wait for the police or whoever to do something about it? And so he went to the media, and so now I think the last update was that the family has been moved off the base and the boy has been banned from going back on MacDill Air Force Base for like 3 years, and that they're continuing to investigate. So, I mean, that just made me think about Rashona's dad, like, you know, God bless the dead, but how did you continue to work for Mr. Kelly after this little conversation happened at this hotel? And why is Mr. Kelly always going to the hotel? Like, why is he having these meetings at hotels? Like, they're just following the same pattern, right? Because we had all this going on supposedly with Aaliyah and this fake marriage that took place, that they was all at the hotel. I'm like, this man got a whole condo, a whole house at the time. Why y'all not going and having these meetings at the house? Why are y'all renting hotel rooms to have these secret meetings? It just don't make no sense to me. But anyway, what else do we have here? Let's see. Let me scroll down here. Shortly after the meeting at the hotel, during the time that law enforcement was okay, so maybe it was because the investigation was going on, so they snuck off to the hotel. Is that why the meeting was held at the hotel, y'all? I don't know. So shortly after the meeting at the hotel, during the time that law enforcement was investigating the first video, Kelly sent Rashona and her parents to the Bahamas and to Mexico for several weeks to get away from everyone who was asking questions about the video, including law enforcement. So I guess that's where the trip come in that they always talking about. So when Rashona and her parents returned to Chicago, Kelly isolated Rashona and placed her in various hotels. Rashona was not allowed to talk to anyone other than Kelly and his associates, and her phone calls were monitored. This continued until Rashona and her family agreed to support Kelly and denied to law enforcement that it was Rashona on video. Why y'all didn't go to law enforcement? Why was y'all going to the Bahamas and Mexico and hopping from hotel to hotel? Why y'all didn't go to law enforcement? I'm confused here. These people get on my nerves. So Kelly was very rich and powerful at this time in his career, and his implied threats of either being with him or against him scared Rashona's family very much. During the state's investigation, Rashona and her parents were subpoenaed to testify before the state's grand jury. Kelly sent one of his lawyers to sit in the grand jury room where and when they testified. Rashona and her parents knew that the attorney was there to report back what they said. Each of them falsely testified that Rashona was not the girl in the video. In video 1, they keep pointing that out. Okay, so Rashona had conversations with McDavid about Kelly. and her. McDavid was present when Kelly's team strategized about what to do with video 1 and its depiction of Kelly engaging in activity with Rishona. Rishona will also describe McDavid's participation in what to do with the necklace and its depiction in both video 1 and her passport photo. In 2008, just prior to and during the state court trial involving the first video, Kelly isolated Rishona from her family and friends and controlled her movements and contacts with others. Kelly's lawyers prepared Rishona on what to say if she were called as a witness. Ultimately, minor 1 did not testify at the trial, and the jury acquitted Kelly. Rishona, who was over 18 years old at the time of the trial, continued to have a relationship with Kelly after the trial concluded. The relationship was sexual in nature and abusive. Rishona ended her relationship with Kelly in approximately 2010, but she continued to have contact with him from time to time after that date. In approximately 2014, for example, Rishona asked Kelly for help with rent payments. At first, Kelly refused. Rishona reminded Kelly who she was, all that she had given up for him, and what she knew about their sexual history together. Not her turning into a blackmailer, child. Kelly threatened her. Kelly thereafter made monthly payments to Rishona by check between 2014 and 2015. Some of the checks were settlement on them, even though Rishona never had a settlement against him. Okay, 2. Okay, we're going to talk about individual 4. So Kelly engaged in a relationship with this person from 1999 to 2001. And she wasn't clear how old she was, I guess, during that time. Let's say 16 to 18. Those encounters occurred numerous times and in numerous locations, including Kelly's recording studio in Chicago and hotels. Once, when she was 16, Brown told her that Kelly wanted her to get a hotel room and wait there for him. Brown wanted her to reserve the hotel room herself, but she told Brown that she could not reserve. She was only 16 years old. So she got the hotel room key by picking it up at Kelly's recording studio. According to her, so they don't go on to say how she rented the room. Okay. Anyway, so according to her, Kelly recorded himself engaging in acts with her, and at least one occasion, Kelly recorded himself having sex with Rishona and her together. They was just freaking nasty. So 3, individual 5. In 1998, okay, hold on. Did we skip over individual 3 and she done dropped out? What individual 3 we said was Tracy Sampson? Did we go over her test? Wait a minute, hold on, let me scroll back up here. 4? No, okay, we didn't drop down to 4. Okay, well, let's keep going. Maybe she in another part. Okay, individual 5. In 1998, when individual 5 was approximately 14 or 15, Kelly engaged in conduct with her. Kelly had threatened her that he would tell her mother that she kissed a boy. Okay, y'all, now this is just getting ridiculous right now. So she felt both fear of and loyalty to Kelly after their first encounter. Kelly told her that they all had secrets now, child. After the first encounter, the continuing until she was 17, Kelly engaged in behavior with her together with Rishona at least 100 times. Y'all, 100 times. 100 times is like every 3 days. That's 365 days in a year. How y'all just 100 times for real? Like, okay. Okay, how long she say her foolishness lasted? Let's see. Let me go back up here and see what this child, what she say, 1998 to, let me see here, let me go back up here. Okay, number 4 was 1999 to 2001. Okay, so she only seemed to have been a couple of times. Okay, it was number 5 who said 1998. 100 times. She said these encounters took place at Kelly's homes, his recording studio, his tour bus, and hotels. These encounters involved Kelly and her alone, her and Rashona together, her and other people, child, including whoever this -6 is. And then it goes on to say that Kelly videotaped himself engaging in acts with 5 with others, including Rashona and whoever is number 6. Number 5 also saw video cameras and tripods everywhere, child, everywhere. At Kelly's Garage Street house, at his recording studio, and on tour buses. She was aware of a false wall in a room at the George Street house that led to a room full of videotapes. Kelly also kept videotapes in his gym bag. In late 2001, CPD interviewed number 5 and her mother and showed them still images from the first video. She identified Rashona in the video, and she then received a subpoena to testify in the state grand jury. Rashona told Kelly about the subpoena. Kelly told 5 that the police were making him out to be the bad guy and that she should say that it was not Rashona in the video. She testified truthfully in the grand jury that she recognized Rashona in the photographs that the prosecutor showed her. I don't know why everybody want to text me at this moment. Let me put this thing on do not disturb. Okay. Sorry about that. Okay, where was I at? Let's see. So she testified truthfully in the grand jury that she recognized Rashona in the photographs that the prosecutor showed her, but she also falsely testified that she did not know of any relationship between Kelly and Rashona. She met with Kelly and Rashona during Kelly's 2008 state trial. Kelly discussed the possibility of Rashona having to testify. Kelly explained to Rashona and 5 that they could beat a polygraph examination by believing the lie being told because there was nothing wrong with what they did together Kelly encouraged Rashona to try and convince 5 to deny that it was her on the tape and to deny that the 3 had any experiences together. B. Testimony of unindicted co-conspirators named in the superseding indictment. The government anticipates that individual B, individual C, and individual D will testify at trial regarding their participation in the charged conspiracies. The testimony that the government anticipates from these individuals is summarized below. Individual B. Individual B met Kelly in the 1990s. Individual B did some concert promotional work for Kelly and some work while Kelly was on tour. Individual B also managed a music group signed to Kelly's record label, and as a result, Individual B spoke with Kelly, McDavid, and Brown about various matters related to the group. In approximately 2001, when Individual B was living in Kansas City, Kelly called Individual B and told him that Kelly needed something recovered and that it would pay Individual B to do it. Later, McDavid and Individual A, a private investigator working on behalf of Kelly, called Individual B and explained that they needed Individual B to recover some videotapes for Kelly and would pay him a reasonable amount to do so. Shortly thereafter, McDavid and Individual A met with Individual B at a hotel in Kansas City, where they informed Individual B that Individual D stole a videotape or videotapes from Kelly and that Kelly wanted them back. Individual B, and we know individual D is Lisa Van Allen. I thought individual B was Yul Brown, but I'm not sure who individual B is. Or could individual B the Damon Friar guy? I'm confused at this point. But anyway, whoever individual B is agreed to help Kelly recover the property. Under the agreement, B was to recover one tape from Lisa to return for $100,000, and B was to recover one tape that Lisa had stolen but did not have any more in return for $1 million. Individual B later entered into a written contract with the private investigator who acted on Kelly's behalf concerning the recovery of the Lisa Van Allen videotape that was no longer in her possession. Well, how were they going to recover the tape if it wasn't in her possession anymore? Okay, the contract was titled Agreement and Reward for Expenses. The contract listed $100,000 plus expenses as the fee to be paid to B, even though the previous agreement was for $1 million. McDavid was present when B signed the contract. Then the private investigator and McDavid explained that the contract was for a lesser amount to avoid raising suspicion. The conditions for payment required B to pass a polygraph examination that B knew of no other copies of the videotape. B learned from Lisa that she gave a videotape that depicted Kelly with someone to a man in Georgia. B provided the private investigator with the man's name, and in turn, the private investigator gave B the man's address. B drove to Georgia and recovered from the address that the private investigator gave him a videotape that depicted Kelly with someone. B made several copies of the videotape. B watched the tape and he observed two scenes of Kelly with Rashona. The first scene depicted Kelly and Rashona on a black and white checkered floor. The video referred to in court 2 as video 2. The second scene depicted Kelly and Rashona engaging in a bedroom, and that's the video number 3 that they're going to talk about in the case. So B returned to Kansas City and met with the private investigator and McDavid at a hotel. There was a polygraph examiner with the private investigator and McDavid at the meeting. And so B gave McDavid and the private investigator only one of the copies of the videotape that B recovered from Georgia and retained the other copies. The videotape that B obtained in Georgia did not contain a separate video of Kelly, Lisa Van Allen, and Rashona. The video referred to in count video 4, in count 4 as video 4. So B asked for payment. The request was refused, and B was accused of making copies of the video and keeping the copies. Okay, so maybe B is the Yul Brown guy, and then was Damon Friar the person that he went to Georgia and got the videos from, or do I have the two names flip-flop? Y'all let me know in the comments. So B admitted that he made copies but refused to submit to a polygraph examination. The meeting became contentious. McDavid and the private investigator told B he would get in trouble for possessing the tapes and accused him of trying to extort Kelly. B remarked that Kelly could go down for having sex on those videos with the people that were on those videos. So Kelly called B after the meeting, and Kelly asked B to smooth things over with McDavid and the private investigator, and he would get paid. B traveled to Chicago and met with Kelly, McDavid, and Brown at Kelly's recording studio. Kelly questioned B regarding the videotape that he recovered and told B that Kelly's life was on the line because he was being investigated for interest in these individuals. And B agreed to turn over another copy of the tape he recovered, but did not tell Kelly that he had even additional copies of the video. Kelly said that McDavid would get him some money as a show of good faith. McDavid gave B $10,000 in cash before B returned to Kansas City. B met the private investigator and McDavid again in Kansas City and submitted to a polygraph examination. The examiner asked B whether he made additional copies of the videotape. B said no. The polygraph examiner determined that B passed the polygraph examination, even though B had in fact made additional copies of the videotape. Oh, Lord have mercy. So there's a note at the bottom that says, as explained below, at this time, law enforcement was investigating Kelly regarding video 1, not these other videos, 2, 3, and 4. So B nonetheless turned over another copy of the tape he recovered in Georgia, and McDavid and or individual A, the private investigator, gave B $75,000 in cash. Over the next years until approximately 2008, B received large sums of money every year or every other year, as payments towards the $1 million he was owed. B never received the full amount. In approximately mid to 2002, B met with Kelly and Brown at Kelly's home in Olympia Fields. Brown placed a videotape into a VCR, and together they watched the scene which showed Kelly, Lisa Van Allen, and Rashona doing the do. The video referred to in count 4 as video 4. Kelly asked B the location of the copy of the videotape that contained that footage, since the videotape that B recovered from Georgia did not contain this scene. B returned to Kansas City and spoke with individual C about this missing scene. So individual C, I think, is Damon Friar. I don't know. It's just so much going on in this paperwork here. Whew. Child, are y'all taking notes? I need y'all to be taking notes so y'all can explain all this to me when this is over and done with. So, C told B that he had a copy of a tape with video 4 and that he knew he would receive money if he returned the tape to Kelly. C showed B the videotape that was with this footage, and B recorded some of it on his cell phone. At some point in the lead-up period to Kelly's 2008 state court trial regarding Rashona and video 1, B met with Kelly and McDavid at Kelly's home in Olympia Fields. B denied having any copies of tapes depicting Kelly engaged in sex acts. Kelly told B that he would be dead, and that's in quotations, if another tape of Kelly engaging in sex acts with someone surfaced. Kelly further stated that Rashona and her family would not testify against him because he relocated Rashona and paid off her family. Kelly expressed concern about B disclosing information about the tapes. The following day, B met with McDavid, who gave B approximately $100,000 in cash. During Kelly's state trial, are y'all following this? So during Kelly's state trial in approximately June of 2008, individual B contacted news media outlets and advised that he was holding a press conference about Kelly. So B is Yul Brown, right? Because he was the one that was going to do the press conference, I believe. And he wanted Kelly to pay the balance of the $1 million owed to him, and he wanted Kelly and his team to know that he was willing to disclose what he knew about the tapes containing Kelly and Rashona, their agreement about the recovery, and their agreement about the recovery of the tapes. Later that day, Kelly asked B not to hold a press conference. That night, Brown gave B approximately $10,000 to $20,000 in cash. The next day, B met with McDavid, who paid B approximately $130,000 to $140,000 in cash. B then canceled the press conference. Lord have mercy. Well, seems like he up to that $1 million by now. All this money they done gave this damn man. So then we go on to number 2, Lisa Van Allen. So Lisa Van Allen met Kelly in late 1997 or early 1998 in Georgia. They began a sexual relationship, a short time thereafter. Kelly liked to videotape them. Kelly convinced Lisa to have threesomes with him and other people, and then Lisa engaged in acts with Kelly and Rishona on at least 3 occasions when Rishona was a certain age. So the first time occurred in a room in the lower level of Kelly's residence on George Street. Kelly set up a camera before the 3 of them began to do the do. Lisa engaged in threesomes with Kelly and Rishona in other places, including on the basketball court in the George Street residence and in a trailer, and each time Kelly filmed it. Kelly kept a duffel bag with him wherever he went. And Lisa Van Allen looked inside the bag and saw that it was full of VHS tapes. In approximately 2001, Lisa searched through the bag of tapes until she found one that contained footage of Kelly, Rishona, and herself in a threesome. The tape had 3 different scenes on it. The first depicted Kelly and Rishona in a room with a black and white chess or checkerboard pattern on the floor, which is video 2. The second depicted Kelly and Rishona in a bedroom, which is video 3. And the third depicted Kelly, Rishona, and Lisa having sex in a room with wood walls on the lower level of Kelly's George Street residence, which is video 4. Shortly after taking the video, Lisa gave it to C, who I'm thinking is LaDamien Pryor. I don't know. Okay. Who lived in Kansas City. Later, Lisa moved to Georgia, where she remained in contact with Kelly through 2007. Okay, well, where the hell was she living? Was she in Chicago? Yeah, okay, so I guess she was in Chicago, then she moved back to Georgia. So in early 2007, Lisa learned that, I'm just going to say individual C is LaDamien Pryor and individual B is the Yule Brown, and it could be the opposite way, but we know that those are the 2 people they are referencing. So learned that LaDamien Pryor still had the video containing video 2, video 3, and video 4. So Lisa knew by this point that a different videotape of Kelly engaging with Rishona had been leaked to the public, and that would have been the first video. So Lisa was concerned that the tape with her engaging in acts with Rishona and Kelly would also be leaked to the public. So Lisa reached out to Kelly about the videotape through an acquaintance. Kelly flew Lisa to Chicago to meet at his house in Olympia Fields. During the meeting, Kelly asked Lisa questions about the videotape and offered her $250,000 to recover it from Damon or Yule, y'all, one of them. So Kelly said that Lisa could divvy up that money however she needed to get the tape back. Kelly further stated that McDavid would handle all of the arrangements. After the meeting, Lisa contacted Damon or Yule, and Damon or Yule agreed to fly to Chicago and return the tape. Brown met Damon when Damon arrived in Chicago. Brown drove the 3 of them, Brown, Damon, and Lisa, to an attorney's office on Jackson Street near the federal courthouse in Chicago. Lisa and Damon met with McDavid in an attorney's office. McDavid and Lisa watched the tape containing video 2 and video 3 and video 4. According to Lisa, McDavid, so I'm taking that as one video that they done cut up into multiple videos, I believe, and I don't understand. I'm wondering if that's even legal for them to do. So if it was one video, then how are they going to make it 4 separate videos and then give 4 separate charges? Seemed like the judge should say, no, you don't get to cut the video up and make multiple charges, right? Or are they saying that because the videos were already chopped up, that's why they can say that there are multiple videos instead of one video that was chopped up? Y'all let me know in the comments what you think. So according to Lisa, McDavid was most interested in the parts that showed Rishona and the multiple references on the tape to Rishona and her 14-year-old body parts. McDavid kept the videotape. McDavid asked Lisa and Damon about whether there were other copies of the tape. McDavid then took Lisa to take a polygraph test in the same building. The polygrapher asked Lisa questions about to whom she had given the tape to and if any copies of the tape had been made. So Lisa passed the polygraph examination. And so Lisa learned that Damon took a similar, so it seemed like they're missing up because I thought it was individual B was the one that took the polygraph test. Now they're saying that individual C took the polygraph test. So I don't even think they know who the hell individual B and C is and who was doing what at the time. Although we know that they are Yul Brown and Damon Friar, we just don't know in what order as they're telling the story. So they said, learned that C took a similar examination but failed because, as Lisa understood it, individual C had made a copy of the tape before traveling to Chicago. After the examination, McDavid gave Lisa and whoever C is $20,000 each in cash. McDavid stated that they would each receive an additional $800,000 when they returned with a copy of the tape that individual C made. McDavid said he would pay Lisa the remaining $50,000 of the $250,000 Kelly promised after Kelly's state trial. So, I mean, McDavid didn't have a problem just passing that money. He was just giving the money away. So later in 2007, Lisa and individual C returned to Chicago where they met with McDavid again. Individual C brought with him another copy of video 2, video 3, and video 4 and gave it to McDavid. Lisa and individual C each took polygraph examinations and they each passed the examinations. McDavid gave individual C $80,000 but only gave Lisa $50,000 in cash. McDavid said that if it wasn't for Lisa, they would not have had to pay individual C $100,000. Lisa returned to Chicago a third time, and Lisa took a third polygraph examination during the visit. Lisa was questioned about matters unrelated to the videotape. The polygraph examiner determined that Lisa failed the polygraph examination. McDavid accused Lisa of being disloyal and threatened her. McDavid ultimately gave Lisa the $30,000. McDavid told Lisa that she would have to talk to a lawyer and deny ever having sex with Rishona. McDavid waited in the hallway while Lisa spoke to a lawyer who later turned over a summary of the interview to Kelly's attorney at the time. During the interview with the lawyer, Lisa falsely denied ever having sex with Rishona. Child, there's just too much lying going on here. So 3, individual C. So between 2000 and 2004, individual C received a VHS tape that individual D from individual D via mail service. So he watched the tape, and the tape depicted Kelly engaged with Lisa and Rishona. In or around 2007, either McDavid or Brown contacted, and guys, when they're saying Brown, they're talking about Milton Brown. They're not talking about Yul Brown. Yul Brown is either individual C or individual B. And at this point, I think they done mixed up the notes, so they just as confused as I am at this point reading this. And explained that they had information about the individual C had a copy of a videotape that they were trying to recover, and that they wanted him to travel to Chicago and return it in exchange for money from Kelly. So Brown later followed up with individual C to make travel arrangements for the trip to Chicago. Individual C showed individual B, so this is Damon and Yul, we don't know which one is which, the videotape before going to Chicago, and asked B for his advice about whether he should go to Chicago. C made a copy of the portion of the tape and took the copy. That is the shorter version to Chicago. Okay, so once again, so since they are the ones that cut the damn tape up, should Mr. Kelly be charged with 4 counts instead of just 1 count of CP? Because he didn't make 4 separate videos. These criminals over here who are extorting money from him, they chopped the video up in order to extort more money from him. So it seems like they are the ones that need to be charged in this case and not him for the distribution and the passing around and whatever happened with this tape. So, Individual C met with McDavid, Brown, and Lisa when Individual C arrived in Chicago. C gave the tape to McDavid and Brown. McDavid, Brown, and Lisa went into a separate room with the tape. McDavid returned and said that what C gave him was not the original version of the tape. McDavid stated that Individual C would have to take a polygraph examination. During the examination, the polygrapher also, asked questions regarding copies of the videotape. The polygraph examiner determined that C failed the examination. C admitted that he kept a full copy of the tape in Kansas City. McDavid instructed C to return to Kansas and to retrieve the original videotape. According to C, McDavid gave C approximately $20,000 in cash to show how serious they were about wanting to get the tape back. C returned to Chicago within days with the original tape he received from Lisa. C met with McDavid and Brown and turned over the tape. McDavid gave C a hug, and Brown said that C had a golden egg. Child, well, what was that? Okay. So Individual C took another polygraph examination where the polygrapher again asked questions about copies of the videotape. The polygraph examiner determined that C passed the examination. During the same trip, McDavid gave C a bag of cash, which Individual C determined contained $80,000. Individual C told McDavid that one day he was going to give the money back. McDavid said not to worry about it because Kelly wanted him, Individual C, to have the money. So 4, Rashona's mammy, what's her name, Valerie? Oh, these piss-poor parents, I tell you. I don't know who raised them. Whew, and caused them to fail their daughters. But anyway, so Rashona's mother is expected to testify that she, along with Rashona and her husband, Greg, who has passed away, met Kelly through Rashona's mother's sister, who is, was Stephanie Edwards, the singer Sparkle. So the first meeting took place approximately 1997 or 1998 when Rashona was in junior high school. Stephanie was a professional singer, and she took Rashona to Kelly's recording studio when she was working on music. Stephanie was in a romantic relationship with Kelly at the time. Ain't this just some foolishness going on here? So around this time, Greg Landfair, who was a professional guitar player, began doing some work for Kelly as a part-time musician. Sometime after Rashona's introduction to Kelly, Rashona told her parents that Kelly was going to be godfather. Okay, Rashona told her parents that he was going to be her godfather, okay. So Rashona's mother found this strange because Rashona already had godparents who were chosen by them. So after that, however, Rashona continued to see Kelly and Kelly's family. Stephanie was with Rashona at times, but at other times, Rashona went by herself. Rashona's mother understood that Rashona was spending time with her godparents, Kelly and Andrea, and their children, which I think at the time they only would have had one, right? And then maybe the middle child was on her way. Okay, anyway. So in around 2000, the Illinois Department of Children and Family Services contacted Rishona's mother and her husband about allegations that Kelly was having sex with Rishona. Rishona's mother and father confronted Rishona about the allegations, and Rishona denied them. In approximately December 2001, Sparkle contacted Rishona's parents and told them that she had a copy of, or had seen a copy of, a tape that depicted Kelly with Rishona. Rishona's father told Rishona's mother that they had to meet with Kelly. Rishona's mother and father met with Kelly and McDavid at a hotel. During the meeting, Kelly said he was sorry. Kelly did not state that he had any contact with Rishona. Kelly said that Rishona and her family needed to leave town right away. Kelly and McDavid said at one point, "You're with us or you're not." Kelly also said, "You're with me or against me," and that some harm would come to the family if they decided to go against him. Now, this right here is sounding kind of made up, y'all. So Rishona's mother and father were frightened, child. They were scared. So Rishona's mother did not want to go up against Kelly's power. Child, what power, Valerie? What power? Money and influence by not following what he said. And so they decided to go along with Kelly's demand and leave town. Child, now where was this? In 2001, 2002. So that dispels this rumor about he sent them away during the trial in 2008. So no, that was a lie, right? So anyway, child, where was I at? Oh, so they decided to leave town. Okay, so after the meeting, Rishona started acting differently. Rishona threatened to harm herself if her parents did not go along with whatever Kelly told them to do. That is, to deny that Rishona was depicted on the tape. Rishona and her parents left town and traveled to the Bahamas and Cancun, Mexico, for several weeks. Rishona's family did not pay for the trip. During their time away, Rishona was in contact with Kelly, and Rishona's father told her that he was in contact with McDavid. Rishona's mother and father and Rishona's family discussed and agreed to do whatever Kelly and McDavid told them to do regarding the tape. Okay, so it sounds like they just wanted some money. Listen, let me tell y'all something. This is not how any of this would have went down in my household, okay? Because first of all, who was picking up Rishona, taking her to Mr. Kelly's house? How was she getting there? Was she jumping on the bus like Geronda and riding 40 miles to get to and from his place? Was somebody sending a car for her? Like, how was this girl getting over there? And where was Drea? Where was Drea when she was going over there? Because didn't Drea say the child was babysitting Joanne and the new baby? Anyway, let's keep on going here. Okay, so let's see. Later, after the family returned to the United States, Rishona and her parents received subpoenas to testify in the state grand jury. Okay, so obviously sending them to Mexico and Cancun didn't stop them from getting that subpoena, and they still had to go before the grand jury. So, child, Valerie met with an attorney, and Greg said he hired by Kelly and McDavid. That they said was hired by Kelly and McDavid. That attorney sat in on the testimony of Rishona, Valerie, and Greg when they testified before the state grand jury. Rishona's mother, so Valerie and Greg, we're going to call them by their name, child. So Valerie and the late Greg had agreed before testifying in grand jury that they would go along with Kelly and deny that it was Rishona in the tape if asked. Rishona's mother was shown a tape depicting Kelly engaged with Rishona during her grand jury appearance, and she was asked if she knew the individuals depicted. Rishona's mother falsely testified that she did not know who is this girl in this tape. Did she pull what's that girl name? What's that actress name that say I feel sorry? Keke Palmer. Did she pull a Keke Palmer and say, I'm sorry for this person in this tape, but I don't know who she is? Oh, Jesus Christ. So C, other witness testimony. Testimony. One, the polygrapher one. Polygrapher one is expected to testify that in or around August 2001, he received a call from the private investigator by conducting a polygraph examination of an individual at a location in Kansas City. So the private investigator described his client as an individual in the entertainment industry from Chicago who was interested in finding out if there were any copies of a certain videotape. Polygrapher 1 understood his assignment to be testing individual B about whether he made any copies of the tape. Polygrapher 1 presented B with an examination permission release form, and individual B refused to sign it or provide his name and instead gave Polygrapher 1 a nickname that Polygrapher 1 wrote on the form. Polygrapher 1 discussed with the private investigator and B the subject to be discussed during the examination before the examination began. They agreed that the focus of the examination would be about the performance tape. Polygrapher 1 wrote this title on the form along with the date August 23, 2001. Polygrapher 1 listed the completed time on the bottom of the form. These notations may mean that Polygrapher 1 did not end up actually administering the polygraph examination, or that he perhaps started the examination but ended it early if B became non-compliant. So Polygrapher 2 is expected to testify that in or around spring or summer of 2000 or the summer of 2001, an attorney with a client in the entertainment business hired him. The attorney told Polygrapher 2 that his client made a tape of him having sex with the babysitter child. So Polygrapher 2 assignment was to determine if the subject of the examination, whom Polygrapher 2 understood to be the person who recovered the tape, made any copies of the tape. The attorney told Polygrapher 2 that he wanted to know the results right away because if the subject passed the test, the subject would receive money. The subject of the polygraph examination was individual B. During the examination, B pulled a VHS tape from inside his pants that Polygrapher 2 understood to be recovered tape that they were discussing during the examination. Polygrapher 2 determined that B passed the examination. As noted above, B is expected to testify that he refused to sit for one polygraph examination despite the polygrapher being present. Okay, child, we got another. Okay, first of all, this whole story is bothering me because these got to be the dumbest criminals of all time. Because if you doing dirt, why is you out here involved? You're involving too many people. Too many people is involved in the scheme at this point. We got the private investigator. We got Yule Brown. We got Damon Friar. We got Lisa Van Allen. We up to 3 polygraphers or polygraphers, however they pronounce it. We got too many people with their hands in this pot. This is just too many people. Too many people. Who came up with this scheme? Like, oh my God. Oh my goodness. Okay. So child polygrapher 3 is expected to testify that Kelly's attorney hired him to administer several polygraph examinations in March and April 2007. Polygrapher 3 created documents that reflect the subject of the polygraph exams, individual C and D, the questions asked, and his determinations. Polygrapher 3 administered polygraph examinations to C on April 17, 2007 at Winston Hotel in Chicago, and again on April 20th, 2007. Prior to each examination, individual C signed a consent form. During the examinations, Polygrapher 3 asked individual C questions about the tape that individual C possessed, which depicted Kelly with Lisa Van Allen and Rashona. So Polygrapher 3 asked C if individual C made copies of the tape. In Polygrapher 3's opinion, individual C failed the first examination and passed the second. Polygrapher 3 administered 3 polygraph examinations to Lisa Lioness, one on March 23rd, 2007 at his testing lab near the federal courthouse in Chicago, 2 April 20th, 2007 at the Swiss Hotel in Chicago, and 3 on July 26, 2009 at his testing lab. Lisa gained a consent form, signed a consent form before each examination. During first 2 examinations, Polygrapher 3 asked Lisa questions about a tape which depicted Kelly, Lisa, and Rashona. Polygrapher 3 determined that Lisa passed the examination. During the 3rd examination, Polygrapher 3 asked individual C, now wait a minute, now hold up, now it says asked individual C whether she had more than one conversation with individual B about the tape and about money. Polygrapher 3 determined that individual C failed the examination. So I think they meant individual D being Lisa in this last paragraph here, because what they saying don't make no dang on sense. Okay, D, polygraph records. Polygrapher 1 and Polygrapher 3 created documents contemporaneous to the examinations they conducted. Those documents included dated and signed consent forms, pre-examination interview forms completed by the examiner, and the examiner's notes listing the questions asked during the polygraph examinations. Further, at least one of Polygrapher 3's consent forms signed by Lisa indicated that she agreed that her polygraph examination results would be released to Kelly's attorney at the time. Okay, y'all, I can't stand dumb criminals. Okay, why would you, first of all, the polygrapher, if any of this is true, the polygrapher shouldn't have known anything about who the client was. This whole setup here should have been between him and whoever hired him. And he should have been given whatever questions they wanted asked, and it shouldn't have given nobody doggone names, right? Because these people just done, they like Hansel and Gretel. They done left breadcrumbs all through the forest for the feds to pick up. Like, this is just utterly ridiculous. If it's true, it's just, I just can't, like, And maybe I'm thinking in terms of technology today. What was going on back then? In 2000, like, you just knew not to do certain things. You knew not to have certain conversations on the phone. You knew not to be recording stuff. If you want to be a criminal, you just can't be leaving. Child, this is crazy. This is like reading a really poorly written novel. Like, ooh, child. Okay, so E, records from individual A's business. So as noted above, the private investigator on behalf of Kelly and in concert with McDavid facilitated the recovery and return of videotapes depicting Kelly engaged with Rashona. So the private investigator owned and operated a business. Billing records from the private investigator's company revealed the following entries, which align with B's testimony about his travel between Kansas City and Chicago, and dealings with McDavid and the private investigator related to the recovery and return of the tapes. So August 13, 2001, 10 a.m. to 11 p.m., travel to Kansas City, Missouri. August 13, 2001, 11 p.m. to 12 a.m., conference at our hotel with individual KW. Okay, well, who the hell is KW? KW. KW. Is KW the private investigator? Oh, no. Okay, wait a minute. These are the private investigators. Was there somebody named Keith Williams that was the security person? Remember in the whole Aaliyah thing, there was a Keith Williams that was traveling with him, that was a good friend of his that he had hired to be like security or something, road manager or something. So that's, okay, I'm assuming that's who KW is. So August 14, 2001, 1:30 to 3 o'clock a.m., conference at hotel with whoever B is. August 14, 2001, 10 to 11:20 a.m., conference with individual KW, call from B to individual KW. August 14, 2001, 3:30 to 8:30 p.m., return travel, Kansas City to San Francisco. August 21st, 2001, 2 o'clock to 5 o'clock p.m., consultations on preparation of reward and expense agreement, telephone conference regarding B extortion with McDavid, and an individual conference call with individual B. So August 22nd, 2001, 9 o'clock a.m. to 12 o'clock p.m., conference calls with McDavid regarding funding, conference calls with polygraphers regarding testing arrangements. And remember, once again, this is the private investigators' notes. So August 22nd to 23rd, 2001, 10:30 p.m. to 6 o'clock a.m., travel San Francisco to Chicago. August 23rd, 2001, 9 o'clock a.m. to 10 o'clock p.m., obtain funding from bank, travel from Chicago to Kansas City, Missouri, conference with B, conference with Polygrapher 2, PSE examiner, and with Polygrapher 1, polygraph examiner, administration of PSE and polygraph tests to individual B, further conference with individual B. August 24th, 2001, 12 o'clock to 2 o'clock a.m., telephone conference with client. August 24th, 2001, 10 o'clock a.m. to 6 o'clock p.m., conferences with individual B and with client, return travel from Kansas City to San Francisco. Individual A's business records also include unsigned and signed versions of the agreement for reward and expenses contract with individual B, as well as memos to file documenting individual A's interactions with individual B, so the private investigator with whoever B is, and polygraphers 1 and 2. F, video 1, video 2, video 3. As noted above, Rishona is expected to testify that she and Kelly are depicted in these 3 videos engaging in conduct that she shouldn't have been engaging in. Law enforcement officers reviewed the videos and determined that they depict the CP. Then there's a note at the bottom that says, while these videos must remain in the custody of law enforcement, they have been made available to the defense for review. G, false documents and entries created as a result of defendants' intimidation, threats, and pressure. So 1, Chicago Police Department report of Rishona's interview. Rishona is expected to testify that Kelly began having contact with her beginning around 1997 or 98. Okay, when Rishona was about 15 or 16, in or about 2000, certain government agencies began investigating allegations that Kelly was abusing her. Kelly instructed Rishona on how to act and what to say if she was questioned. In or around December 2000, law enforcement officers from the Chicago Police Department questioned Rishona about her relationship with Kelly. During the interview with CPD, Rishona falsely denied the allegations of Kelly's misconduct, and the Chicago Police Department documented that information in a police report. In summary, the police report states that law enforcement interviewed Rishona, who stated that she had never been abused by Kelly and that any such allegations are untrue. 2. Rashona, her mammy, and her pappy. Oh, child, their state grand jury transcripts. During the state's investigation leading up to Kelly's 2002 state charges related to Video 1, Rashona, her parents, and individual 5 testified before the state's grand jury. Rashona and her parents testified falsely about whether Video 1 depicted Rashona. Then whoever number 5 was untruthful about the fact that Rashona and Kelly had a relationship with Rashona when she was under 18. Those false statements appear in their respective grand jury transcripts. So basically, we can be rest assured that the reason whoever number 5 is, that they have threatened her with prosecution for giving the false statement in order for her to testify, to force her to testify. So, memorandum of individual D's interview, which is Lisa Van Allen. So, as set forth above, Lisa Van Allen is expected to testify that following her third polygraph examination on or about July 26, 2017, that McDavid told her to meet with other lawyers and tell them that she never had sex with Rashona. McDavid waited in the hallway as Lisa went in the room to meet with the lawyers and provide the false statements McDavid instruct her to provide. The attorney prepared a memorandum of interview dated July 26, 2007, documenting Lisa's false statements. In summary, the memorandum states that Lisa provided the following information. Lisa knew Rashona and had spoken to her on numerous occasions. Lisa never saw Kelly in a situation with Rashona, and Rashona was never a participant in any encounter with Lisa and Kelly. Lisa agreed to be interviewed by attorneys on July 26, 2007. Lisa was not forced, threatened, or promised anything to participate in the interview. Lisa is expected to testify that the underlined information, which is what I just read to y'all above, is false, and that she provided the false information at McDavid's direction. H. Travel and credit card records. Oh my God. Jesus. Just leaving a paper trail. If all of this is true, just leaving a paper trail for no apparent reason. So records from the Atlantis resort in the Bahamas show that Rashona and her parents stayed there in February 2002. I still don't understand why this is important, because number one, it happened in 2002. When they returned, they still spoke to the grand jury, and they had the opportunity. They had 5-6 years to tell the truth. If they're saying that what they're saying now is the truth, now they had 6 whole years between when they gave the grand jury testimony and when the actual trial took place to tell the truth. They had the opportunity on the stand to tell the truth. They had from 2008 up until 2019 to tell the truth, and they decided to continue with the lie. So this trip is totally irrelevant because it happened before she testified before the grand jury. So anyway, child, the United States from Cancun, Mexico in February 23rd, 2002. CBP records also show Brown returning from Nassau, Bahamas on February 1st, 2002, and then from Cancun, Mexico on February 21st, 2002. So Milton Brown went on the trip with him. Okay. So a representative from a travel agency is expected to testify about records related to Kelly and his companies, including Bass Productions. Those records include credit card authorization forms, which document reservations the Kelly-related company made for Lisa and Damon and Yule and anybody else that needed a plane ticket at this point. Child, I probably could have got a plane ticket. Okay, to meet with Kelly, McDavid, and Brown, and to take polygraph examinations, including the following. Haven't we already gone over these dates? March 23rd through 26th, 2007 at Matson, Illinois hotel reservation for Lisa, the date of her first polygraph examination. April 16 through 18, 2007 at the Westin Chicago River North Hotel, reservations for Brown for 1 suite and 3 rooms for individual C. First polygraph examination was on April 17th at the Westin. April 19th through 21st, 2007 at the Omni Chicago Hotel, reservation for 2 rooms for individual C and Lisa. Both were in Chicago for polygraph examinations on April 20th through 2007. And then on April 19th through the 21st, 2007 at the Swiss Hotel, Chicago Hotel, reservation for Brown. Lisa's second polygraph examination was on April 20th, 2007 at the Swiss Hotel, and July 25th through 26th, 2007, Chicago Hotel, reservation for Brown, which was Lisa's third polygraph examination, which was on July 26, 2007. Credit card records for accounts belonging to the same travel agency show the following charges: Western Hotels, River charges. So basically the hotel charges match with what I just said. Neither Rashona nor Rashona's mother recall seeing Brown during their overseas travel. So I guess it was a coincidence that that he was in Cancun with them at the same time. They don't know why he was there, but I guess he was watching. I don't know, child. I guess that's what they want us to think. He was spying on them, making sure they wasn't talking to nobody, making sure they was staying at their hotel and hadn't snuck off the islands and gone no damn where else. Oh, Lord, have mercy, y'all. Are y'all following this story? Like, is this not the craziest thing? Is this not the craziest thing that y'all have heard? Like, they just, I don't know, child. Anyway, what was I? Airline ticket purchase for, I'm going to say Damon Pryor for travel from Kansas City to Chicago, April 19, 2007. His second polygraph examination was on April 20th. 2007, Omni Hotel charges for arrival and departure dates between April 19th and April 21st, 2007. The travel agency reserved rooms for... Who was Lisa in the relationship? Was she in the relationship with Yul Brown or Damon Pryor or both of them? Because they had separate rooms at this hotel, so they weren't dating each other. So additionally, credit card records for accounts McDavid showed the following charges: Omni Hotel charges with arrival and departure dates April 19, 2007 and April 21st, 2007. The travel agency reserved rooms for, I guess, Damon and Lisa or Yul and Lisa at this hotel during this time. Swiss Hotel Chicago charges with arrival and departure dates of April 19, 2007 and April 23rd, 2007. Lisa's second polygraph examination was on April 20th at Swiss Hotel, and the W Chicago Lakeshore charges on July 26, 2007. The travel agency reserved rooms for Brown for a July 25th through 26, 2007 stay at W Chicago, and Lisa's third polygraph examination was on July 26, 2007. Bank documents. Records from various financial institutions reflect the following payments in keeping with the allegations in the superseding indictment. September 2008, Bass Productions check signed by McDavid to Rashona's father in the amount of $30,000. June 30th, 2009, wire payment from Bass Productions to pay, I guess, Yul Brown or either Damon Pryor to settle a lawsuit in the amount of $125,000. On September 17th, 2017, Bass Productions check in the amount of $200,000 to Brown, which was cashed the same day as noted above. I guess Damon Pryor or Yul Brown and Lisa each received $20,000 in cash. on April 17, 2007, and $80,000 on April 20th, 2007. Okay, let's see. So he cashed a check for $200,000, and the same date, C and D both received $20,000 in cash, so that's $40,000, and on April 17, and $80,000, so 80 and 80, 160. So I guess that totals $200,000. Okay, monthly payments from January 2014 to October 2015 from Kelly's business to Rishona in the amount of $1,150. What was he paying her rent? I mean, that don't sound like no bribery to me. That just sounds like he was paying her damn rent. Okay, in August 2014, wire transfer from Kelly to McDavid in the amount of $80,000, and a December 2015 wire transfer from Kelly to McDavid in the amount of $10,000. 3, I swear it's almost over, y'all. I think it's like one more page. Conspiratorial statements. The co-conspirators, in addition to the defendants as charged in the superseding indictment, include the private investigator, Yul Brown, Damon Pryor, and Lisa Van Allen. Individual A, the private investigator died, y'all. He passed away after the relevant events in the case. Now we left with Lisa, child, to the extent that she was involved in securing, retrieving, and concealing the tapes depicting Kelly engaged in activity, was co-conspirator of the other individuals involved in those activities. But Lisa, with whom Kelly engaged in sex right around the time Lisa turned 18, was also a victim of his conduct. Now, she was a prostitute when he met her. She was a hoe already. She was a willing participant. She wasn't no damn victim. So the statements between the co-conspirators in furtherance of the conspiracies involving obstruction of justice and receipt of the videos fall into numerous categories concerning subjects integral to the conspiracies, actions in furtherance of the conspiracies, and to the success of the conspiracies. The statements are too voluminous to be listed in their entirety in this proffer. As a result, the nature of the statements are described by category below. This list provides an illustration of, but not an exhaustive description of, the nature of these statements. And then there's a note that says, as set forth above, the number of out-of-court statements from these sources will be admissible without regard to the co-conspirator hearsay rule, because they are statements of the defendant's statements not offered to prove the truth of the matter asserted or for other reasons. I don't know what that's, anyway. So they're taking statements that he made, but they're saying that they're not actually relevant, but they're going to use them anyway. Okay. So the statements of co-conspirators made in furtherance of the charged conspiracies include the following category of statements. 1, statements made by the private investigator, Yul Brown, Damon Pryor, and Lisa Van Allen to each other, to others, or in documents in the course of collecting and returning to defendants tapes depicting Kelly engaged in acts with Rishona. These statements include, for example, those related to booking travel and making arrangements to meet with defendants for the purpose of returning the tapes. Statements made by the private investigator, Yul Brown, Damon Pryor, and Lisa Van Allen to each other, to others, or in documents regarding payments received or owed to collect and return to defendants videotapes depicting Kelly engaged in acts with these people, or to ensure that they would not cooperate with law enforcement or otherwise disclose regarding such activity. 3, statements made by the private investigator, Yul Brown, Damon Pryor, and Lisa Van Allen to each other, others, or in documents regarding polygraph examinations administered concerning Yul Brown, Damon Pryor, and Lisa Van Allen's knowledge of or efforts to collect and return to defendants videotapes depicting him engaged in acts with minors. Oh, Jesus. So the statements proffered in the preceding section of the submission of Van Allen, Pryor, Brown, and the private investigator constitute co-conspirator statements under Rule 801 D2E because they are statements of co-conspirators in furtherance of the conspiracy. These statements combined with the anticipated testimony of Rishona and whoever 4 and 5 is and the other evidence set forth above demonstrate the existence of conspiracy, the defendant's knowing participation in it, and the acts they committed in furtherance of it. The statements of the defendants, to the extent they are not otherwise admissions, constitute co-conspirator statements under Rule 801 D2E. The statements in the private investigator, Yul Brown, Damon Pryor, and Lisa Van Allen fall squarely within 801 D2E as well, and the government requests that they be admitted on that basis. And then there's a note on the previous page that says the government is not detailing each and every proposed co-conspirator statement of each witness or document, but rather a representative sample of the statements from each witness and or document. Further, by attributing statements to particular witnesses, the government is not committing to call each of the witnesses for each of the statements attributed. Of course, the government is committed to establishing the Bure Jolly, predicates at trial, Borgelli, I guess things that were said in jail, in the predicates at trial, and the ultimate admissibility of co-conspirator statements is governed by the trial evidence. Conclusion: the above is an outline of the evidence that the government will introduce to establish that the charged conspiracies existed. Based upon this proffer, the government respectfully requests that the court find that categories of co-conspirator statements listed above, as well as co-conspirator statements like them, are admissible pending the introduction of evidence to support this proffer. And then before I go, guys, I am going to read to you what the federal rule 801 D2E actually states. So hold on a second. Okay, so Rule 801, definitions that apply to this article. Exclusions from hearsay. The following definitions apply under this article. And so we are looking for, what are we looking for? So that's 801. And we're looking for D2E. Okay, D2E. So D states, statements that are not hearsay. A statement that meets the following conditions is not hearsay. 1, a declarant witness prior statement. The declarant testifies and is subject to cross-examination about a prior statement and the statement. And actually, we're going to 2. We don't need to worry about 1. 2 is an opposing party statement. The statement is offered against an opposing party, and E, was made by the parties co-conspirator during and in furtherance of the conspiracy. The statement must be considered but does not by itself establish the declarant's authority under C. And C is was made by a person whom the party authorized to make a statement on the subject. The existence or scope of the relationship under D, which was made by the party's agent or employee on a matter within the scope of that relationship and while it existed, or the existence of the conspiracy or participation in it under E. So basically they're saying that whatever The private investigator who then went on to glory, not Yul Brown, but Milton Brown and Darren McDavid, whatever they said to the Landfairs and to Lisa Van Allen and crew is admissible hearsay, even though Mr. Kelly wasn't there. It's admissible because they were all co-conspirators. So it doesn't matter if he was there, if he knew about the statements or whatever, because they were co-conspirators, he's responsible for what they said. Basically, like I told you guys in the Eastern District of New York, with the count regarding Aaliyah, it didn't matter if he told Demetrius Smith to go and bribe the public official. It doesn't matter if he told Darren McDavid to go get the $500 to pay the public official, because they were his employees. They were considered co-conspirators, and he was responsible for whatever they did. So that's it for me. And guys, remember, I have some other videos coming with the motions in limine and the I believe the appeal request that Jennifer Bonjean filed. And then also, you guys, I did a video, I think my last video was where Jennifer Bonjean had filed a lawsuit against the MDC. So that's sort of a moot case, moot M-O-O-T case at this point, because after she filed the lawsuit, they removed him from the S Watch, and he has since been transferred from the MDC back to the MCC in Chicago. And so I don't know if she's just going to let it go. I know they were still trying to find a judge. The first judge that was assigned the case withdrew from the case. They didn't want to be a part of it. And so she may just let that go, or she may just keep it up and say, well, you know, we're going to put an end to this putting folks on watch who are celebrities, so that y'all can make them look bad and all this stuff in the public eye. So she may be continuing with it, or they might just say they removed him from the watch, they transferred him from the prison, and it's over and done with. We'll have to wait and see. But I did have a document where she responded to the judge, to the magistrate, saying that it was a moot issue. But I don't know if they were saying having him removed was a moot issue because they had removed him, or if they were saying that the whole thing was a moot issue. We will have to wait and see. But anyway, guys, that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.